Hello and welcome to this session in which we will discuss Chapter 7 bankruptcy, which is liquidation. Remember, Chapter 7 liquidation can come along as voluntary where the debtor is filing for this Chapter 7, or it could come involuntary when the creditors force the debtor to go into bankruptcy. Also remember that both individuals and businesses can file for Chapter 7 liquidation. Now, under the bankruptcy law, what's the purpose of Chapter 7? Chapter 7 is to give honest debtor, people that want to get out of this debt, honest debtor, the option, the chance to eliminate most of their debt, not all their debt. Why we say most? Because not all debt is discharged. And we're going to see certain that it's not discharged. So the process is known as discharge for individual. If it's a corporation, we use the term dissolve, which frees the debtor from personal liability for these debt. Simply put, you're starting fresh. There are certain exceptions and scenarios where this charge may be contested or denied. They denied by the court or the people, the creditors. People means the creditors. They can contest this. Why? Because the creditors don't want you to go into a bankruptcy. They want to be paid, especially the unsecured creditor. So in this session, we would look at these different scenarios, and also we would look at the distribution. When the Chapter 7 takes place, how do we distribute this money? Because whatever's left will have to be distributed from the estate. But we start by looking at when the Chapter 7 is either contested or denied. Let's go ahead and get started. Before we proceed any further, I have a public announcement about my company, farhatlectures.com. Farhat Accounting Lectures is a supplemental educational tool that's going to help you with your CPA exam preparation as well as your accounting courses. My CPA material is aligned with your CPA review course such as Becker, Roger, Wiley, Gleam, Miles. My accounting courses are aligned with your accounting courses broken down by chapter and topics. My resources consist of lectures, multiple choice questions, true-false questions, as well as exercises. Go ahead, start your free trial today. The first reason why with Chapter 7 bankruptcy will be contested or denied is the debtor intentionally hides, transferred, or destroyed property to avoid paying creditors. Well, they can contest this, say this individual is doing this on purpose, doesn't want to pay us. The court might grant them. So if Sarah transferred her expensive jewelry to her friend to avoid being used to pay her debt right before filing for bankruptcy, this could be ground for discharge. Why? Because Sarah is not acting in good faith. If she owes people money, she's not supposed to transfer her jewelry to her friend. 2, the debtor is not keeping good books and records. What does that mean? It means we really don't know what's going on with them. If the debtor fails to maintain proper financial record, making it hard to determine their financial situation or transaction, their discharge could be denied because the assumption here you are hiding something. So if Mike, a small business owner, does not maintain proper financial records and it's impossible to determine his business transaction, he might be denied the discharge because we really don't know whether this discharge is true, whether this Chapter 7 bankruptcy petition is true, or if it's fraudulent. Also, if the debtor had prior discharge within 8 years, so he could do this every 8 years. The debtor can only receive Chapter 7 discharge once in an 8-year period. So if Lisa received a discharge 6 years ago, she can't receive another discharge until 8 years has passed since this last discharge. As I mentioned earlier, not all debt is discharged. Most of the debt is discharged, but there are 6 types of debt that they are not discharged. Alimony, fraud, taxes, we're going to look at the details of each one of those. Education loan, debt undisclosed in a bankruptcy petition, willful and malicious injury. Now what you want to do, you want to memorize them. How would you memorize them? Try to figure out a mnemonic for those and try to memorize them. But hopefully they will make more sense as I go over each one of them separately. Starting with alimony. Obligations such as alimony or support owed to spouse or child, which is child support from a divorce or separation agreement, are not dischargeable. This has to do with the family court, and the bankruptcy court don't get involved. So those debt are not discharged. So if Sarah owes alimony to her ex-spouse, this debt would remain after the bankruptcy. So it's not discharged. Fraud. Debt incurred through fraudulent means. So you got this loan, but through fraudulent means. Guess what? you're going to carry that loan, including credit card debt where the credit was obtained through false pretenses, are not discharged. So if you applied for a credit card, you lied on your application, and they find that out later, then your debt cannot be discharged. So if Mike uses false information to obtain a credit card and racks up debt, this debt will be exempt because it was obtained fraudulently. Also, willful and malicious injury, debt from injuries caused by intentional and malicious act by the debtor, are not discharged. A prime example of this is DUI. Driving under the influence, you got into an accident, you injured someone, this is considered willful and malicious, or any willful or malicious for that matter. So if John intentionally damages his neighbor's car, any debt resulting from this act will not be discharged. Also, the fourth one is taxes. Certain taxes, especially the recent income tax debt or taxes owed to government agencies, are not dischargeable, usually the past 3 years. For example, if Lisa has unpaid taxes from the last 3 years, this will be likely not being discharged in a bankruptcy. Now, bear in mind, this is law, so we'll always have exceptions, but those are the general rules. Same thing for educational loans. Generally, student loans or educational obligation are not dischargeable unless repaying them would impose an undue hardship on the debtor. What's undue hardship? Again, each case is different. For example, if John has substantial loan debt, he would typically still be responsible for this debt, even if John filed for a bankruptcy, unless he can prove undue hardship. Also, debt undisclosed in the bankruptcy petition. Any debt that were not listed or disclosed by the debtor in the bankruptcy are not discharged. If you remember in the prior session, I said one of the debtor's responsibilities is to list all their creditors. So if you did not list one person, you did not list them, guess what? They're not going to be discharged. So if Sarah fails to list a personal loan in her bankruptcy filing, she would still be liable for that debt. Let's talk about reaffirmation of debts. In bankruptcy proceeding, there are under certain circumstances, a debtor might choose, yes, they wanted to choose, not to have a debt discharge. What does that mean? It means they don't want this debt to go away. They said, in the bankruptcy proceeding, keep this debt out. I am willing, I want to pay it. This usually occurs when the debtor wishes to maintain a positive relationship with a particular creditor, because they might have a business and they're planning to start the business again and they don't want to upset the supplier. Therefore, they would say, keep it out of the bankruptcy. To achieve this, the debtor can opt out by something known as reaffirmation of debt. Now, when they do make that choice, the court wants to make sure that this choice is not made under duress. The creditor is not threatening that individual. That's why it's called reaffirmation, making sure. Reaffirmation involved the debtor making a formal agreement to continue being liable for the debt even after bankruptcy. Now, bear in mind, you have to go into this agreement must be made before the bankruptcy discharge is granted. Once the bankruptcy discharge is granted, you're legally off the hook. Once the discharge is issued, this debtor can no longer choose to reaffirm a debt. Example. Let's example Jane has a loan from the local bank and she values her long-standing relationship with that bank. So if she filed for bankruptcy, she might decide to reaffirm the loan to the bank. By doing so, she agrees to keep paying it off as if the bankruptcy did not exist. This choice would help her maintain her relationship with the bank and demonstrate her commitment to fulfilling her financial obligation. Maybe the bank will help her again start to build a credit after the bankruptcy. Reaffirming a debt is a significant decision, and it means the debtor will continue to owe and be legally responsible for that debt despite the bankruptcy. So be careful when the term reaffirm appear in a multiple choice questions. What does it mean? Now we'll get to the distribution of the proceeds. What does that mean? It's after the debtor assets are collected. Remember, we have this bankruptcy estate we talked about in the prior session. We have all the assets, all the resources that the debtor has in an estate. Then we sell everything, and when we sell everything, we distribute this money to the creditors. But the question is, who gets money first? You might have many creditors, different creditors. Well, there are three main categories of claimant. We're going to have secured claimants, priority claimants, and unsecured claimants. Secured, pretty explanatory. We should know who these are. Those creditors who have their loan backed by a collateral. They are paid first, up to the value of the collateral though. If their claim exceeds the value of the collateral, any remaining amount is treated as a general creditor claim. So it goes from Group 1 to Group 3, general, unsecured. What does that mean? If a bank has a mortgage on a debtor's property for $100,000 and the mortgage owed is $120,000, the bank will receive $100,000 and $20,000 remain unpaid. So what's going to happen? They owe $120,000. They were able to satisfy $100,000. The $20,000 becomes unsecured. So the bank now stands with the third group, with unsecured claimant. So the first party are the secured. They have attachment, they have perfection, they'll get paid first. The third group, I'm going to go from the first to the third. The third group are the general creditor. These are all other creditors who filed their claim on time. They are paid after secured and priority claimants. So who are the priority claimant? We'll talk about those shortly. If the available funds are sufficient to pay all the creditor at a particular level, they are paid. If the sufficient fund are not sufficient, are insufficient to pay all the creditors at a particular level, they are paid on a pro rata basis. If at the end we have $100,000 left for this group and we have 10 general creditors and we cannot pay them off all, so what we do, each will receive, assuming they have equal claims, each would receive $10,000. We would distribute it at a pro rata. So if, for example, we have 100,000 and they have different ratios, then we will distribute this 100,000 based on the balance of the ratio. So if one has, 300,000, the other individual has 400,000, and one 200,000, and one is 100,000. So the remaining amount is 100,000. We have 100,000 left, and here's $1 million. We have $1 million in claims. What's going to happen? This is A, B, C, D. A is 30%, B is 40%, 300 divided by $1 million, 400 divided by $1 million. This is pro rata. So A will get 100,000 times 30%. B will get 100,000 times 40%, so on and so forth. This is what we mean by the pro rata. Now let's discuss the priority claimant. Remember, this is group 2. Okay. These are creditors who have specific priority as defined by the bankruptcy law. So now what we're doing, we're going to go through group 2 and we're going to have many of them and we're going to give them a priority. So the first priority in group 2 is any support obligation. This includes alimony and child support owed to spouses and children. Hold on a second. Didn't you say that alimony and child support are not dischargeable? True. Alimony and child support are not dischargeable, and also if you have money, you have to pay them after you pay the secured creditor. They become the first priority in this priority claimant group 2, and they are not dischargeable. So let's assume we don't have any money for group 2. Guess what? The people that expect to receive alimony and child support would still receive their money regardless. That is not discharged. But if you have money, you have to pay them, because this matter will be solved in a family court, not bankruptcy court. 2, after you pay alimony and child support, assuming you have a family and you're paying your ex-spouse, you're paying child support. After you pay this group, if there's any money left, you have to pay the bankruptcy administration expense. You remember, you have the trustee, you have court fees, you have filing fees, you have to pay those first. So trustees need to be compensated because they're in charge of this whole process. 3, post-petition business claims. Who are these people? Post-petition business claim. Here we go. If we have a timeline, at some point, there was petition to file. Petition to file. And we're going to say this happens March 1st. So petition to file happens March 1st. Now, between March 1st until the courts review it, it may take it till April 10th. Between March 1st and April 10th, because the court's going to review if it's involuntary claim, this period is called post-petition. So anyone who got involved with the business, with the debtor during this period, post-petition business, that accrued in the normal course of business after an involuntary, remember this is involuntary, otherwise if it's voluntary, the petition to file takes place immediately and it's effective immediately. For involuntary, it takes some time until the court reviews it. Therefore, we have this period from March 1st till April the 10th. So the businesses that were involved with the debtor will get paid next. So again, petition date to order of relief date. Remember, the order of relief date is when the official starting bankruptcy, which happens to be in our example April 10th. Petition date was March 3rd. So you need to know what a petition date and order of relief, or when the actual bankruptcy starts, April 10th. Then we have, if you have employees, employee wages claim. Limited to wages earned within 180 days of the bankruptcy up to $15,150. So how much? So if the people work for you, how much can you pay them up to? $15,180, and they have to be 180 days of the bankruptcy. What's the bankruptcy? The order of relief. This is how much you have to pay. Then we have employee benefit claim. Funds owed to employee using any remaining part of the $15,150. So you might be paying wages and you might have benefits. Well, you have to pay the benefit next. So if you pay them wages and $10,000, they still have the difference. $5,110 could be paid in benefit. You have to pay those first, but wages are first because they need the cash to live. Now, bear in mind, these numbers, once I highlight in yellow, it means those numbers could change. So if you're looking at this recording a few years down the road, they might change these figures. That's fine. Don't panic. It might be 17, it might be 18, depending on inflation. Then we're gonna play claims of grain farmers and fishermen. Why? Because we like farmers, we like fishermen. We want to make sure that they are paid up to $7,475. That's in group 2, 6 category. The 7th category, if you made a deposit somewhere, you went to Home Depot, you put a deposit, you rented a piece of equipment, Home Depot went out of business. Well, guess what? They will give you $3,350, assuming they have money. You'll be standing in line at number 7 in group 2, and the maximum you will get is $3,350. Then you have tax claim, various government tax claims. Hold on a second. But didn't you say that tax claims are not dischargeable? Yes, tax claims are not dischargeable. If the government can get paid here, they will be happy to take the money. If they're not paid here, no worries. You're not going anywhere. They're going to get you later because the debt is not dischargeable, just like the group 1. The support obligation is not dischargeable. Then you have claims from drunk driving injuries or any willful injuries, personal injuries, claims due to intoxicated driving. Then they will be paid. That doesn't go away. Then they will be paid, specifically this group. Now, what's the third group? If these are all paid, then we have the unsecured. We talked about them, group 3. Now, be aware of the following. I know I mentioned this, but I'm going to repeat it. Payment are first made to secured creditors up to the value of the collateral, because on the multiple choice, they will try to trick you. So if, remember I said you owe the bank 120, your home is worth 100, what's left is 20. This 20 doesn't go away, this 20 go to group 3. Any claims exceeding the collateral are treated as a general creditor. And also remember that payment follow priority rules, irrespective of the discharge exception. So they might trick you to say, well, you don't have to pay child support. You can skip over them because they're not discharged. No, although it's not discharged, you still have to pay them. Same applies for the government. Post-payment, remaining debt are discharged unless there are exceptions. Once all the payments are made, all the other debt is discharged unless there are exceptions. For example, the exceptions were what? If we look at them, were 1, 8, 1, 8, and 9. Those are exceptions. They don't go away. Now, paid taxes claim, they don't get paid. So even if you paid up to the 4th priority and nothing left, they would still exist. You would still be responsible for them. Let's take a look at the multiple choice questions from farhatlectures.com. What happens to debt that exceeds the value of the collateral in a bankruptcy? They are fully discharged. Are they fully discharged? I hope you still remember they're not fully discharged. They don't go away. They are partially discharged. Are they partially discharged? Means some of them are discharged. No, I would say no. They're not partially or fully. They're not discharged. The debt that exceeds the equity. It means you owe, let's use the same example again. The debt is 120. The collateral is 100,000. 20,000 remaining. It's not discharged, not partially, not fully. They are treated as priority claim. No, they are not treated in group 2. This is group 2 priority claim. They are treated like claims of general creditors. Yes. So this 20,000 is treated as claim as general creditor. Now you may or may not get anything. Nevertheless, It's part of the general creditors. So the answer is D. The reason I mention this because this type of questions is important. What do you want to do next? You want to go to Farhat Lectures, look at additional MCQs where I have AI CPA questions, additional business law questions. That's going to help you prepare for the CPA exam. Invest in yourself. Study hard, good luck, and of course, stay safe.